Thank you so much for that intro. Thank you for having me here today. The clinic is such a vital tool for our community work. As was mentioned before, community work is very important to me. It's near and dear to my heart. I've been doing it ever since I got called to the bar, even before that, quite honestly, right? And it's very important because I find that our community does not always have access to this type of information, right? And it's very vital to our economic advancement, right? That we sort of get the answers to the test and realize exactly how these different aspects play and tie into our day-to-day lives. And so thank you so much. I see some familiar faces in the audience, some people I haven't seen in a while. Thank you for braving the weather and being out here today for us to have a sort of discussion about wills and estates, okay? And so we'll dive right into it. As mentioned before, we'll have a question and answer period, so if you want to jot down some notes, feel free to do that. But if it is something that's burning and you don't want to forget, just raise your hand and I'll call on you, okay? Because I want it to be interactive as possible as we go through the process, okay? And so, this lawyer speak, there's a disclaimer here that obviously none of you are retained by me, right, officially. And so this is just for public education. And like I said, if there needs to be any further discussion, we can arrange for that to happen. But from time to time, I like to be able to do these PLEs because, like I said, I think that it provides sort of clarity to the community, all right? We're not going to go over that. That was already mentioned before, but it just talks about my history and a brief overview of what we're going to go over today, all right? And so first of all, we're going to start with some definitions. We're going to talk about power of attorney, right, and what that means and everything that entails. And then we'll talk about why it's important that you have a will, right, and what happens if you were to not have a will, right? That's what we're all here today to sort of figure out. We'll also delve into what a will even is, in terms of a legal framework, and also give you some insight as to what should be included inside of the will, all right? And so we start with some humor. We're a little bit late for Thanksgiving, but U.S. Thanksgiving was about a week or so ago, and so the turkey is with his lawyer, and he's saying, and Farmer Brown gets nothing if I die under suspicious circumstances. Right? So he's the turkey's getting his affairs in order before Thanksgiving rolls around, right? Here's another one. Ever since my husband died, there has been no end to the trouble with his estate. Meetings with solicitors, letters, papers, opinions from counsel, conferences, fees, litigation expenses, briefs, court hearings, more fees, I don't know what. Sometimes it makes me wish he hadn't died. Right? Right, and so there's injecting some humor into like a morbid topic, but sometimes you sort of see that the death ends up being sort of secondary to all the things that surround estate planning, right? And so with all that, we start off with navigating the wills and estates process. So we start off with definitions, right? And so power of attorney. These are documents in which a person grants power over his or her assets or personal care to another individual. Don't worry about memorizing these. Like I said, we're going to go into these things more in depth, right? This is just to give you a broad overview of the definitions. A will, a document that sets out a person's wishes and directions with respect to the disposal, and disposal doesn't mean throwing away, it means granting it to another person, of his or her property after death. A testator, a person who makes a will. That would be each and every one of you, hopefully, after this presentation, if you don't have one already. And testatrix, a person who makes a will, that's the female version, right? You've all heard of a trust before. That's the means by which money can be held by an individual or an institution, who is a trustee, for the benefit of another, who is the beneficiary, according to the rules governing the trusts. And so if you want to set up a trust, you would go to a lawyer or someone authorized to do so, and they can set that up for you and sort of give you sort of the ins and outs with regards to the process. Further definitions, settler or testator, the person who transfers the property is the person who sets up the trust. In case of a testamentary trust, this person is called the testator, or the deceased. In the case of an inter vivos trust, the person who sets up the trust is called the settler. So again, these are all semantics, right? Bottom line is this: you, the individual, granting your rights in property to another individual. Okay. The trustee is the person to whom the trust property is transferred. They are called the trustee. The beneficiary, the person from whom the property is held, for whom the property is held. There's another word, intestate, which is a state of dying without a valid will. That's what we're all trying to avoid, and we'll go into the reasons why that's important later on. And escheat, the forfeiting of ownership to the crown for lack of heirs. And so this is a situation we're really trying to avoid, right? We're going to go into it later on, what happens when you don't have a will or any sort of heirs that are apparent. It ends up going into the crown. And who is the crown, everybody?
The government.
The government. And do we want to give all of our finances and our property to the government? Okay, good. We're all on the same page then with regards to that, okay? So moving forward with advanced directives. And so this is just a formal word for power of attorney. And so here is, if you're any Avenger fans in the audience, any Marvel fans, the lawyer's talking to them and said, well, I was bitten by a radioactive lawyer and ended up with the power of attorney, right? So this is just a play on words. That's not what power of attorney means, right? It's not any sort of supernatural, mystical power. We're going to go into what it actually means, right? And so power of attorney. We will cover, this is the overview of that, defining what a power of attorney, and because I don't want to say power of attorney a million times, I'll say POA moving forward, right? The three types of POAs, the powers that are granted in a POA, and the formal requirements in creating a valid POA, okay? So power of attorney, POA. In Ontario, the POA is a legal document that gives someone you trust the authority to make decisions on your behalf and represent you to others. Okay? This authority can be granted, can be general or limited in to specific acts that the attorney can perform. So bottom line with this is that you are the author of this document, obviously, right? You can make it continuing in general, you can make it very specific, right? Just things that you need to know with regards to the POA. And so this ability is given in advance by you, who are the grantor of the document. A power of attorney is something you never hope that will have to come into effect, but it can protect your finances, health, and personal decisions if you were to become incapacitated. And we'll go sort of like deeper into what we mean by you hope you never have to use it. It's break in case of emergency, right? A great way to think of your POA is as a form of disability insurance. It helps protect you while you are alive. And the reason why that's important is obviously that is different than a will, which kicks into effect upon you passing, right? So your attorney is responsible for making decisions about your property, finances, personal life, medical care, in the event of an emergency if you are unable to do so yourself. In many cases, you can also help your attorney by outlining these decisions in advance. Okay? So the power of attorney is a very powerful document, right? And the reason for that is that the person you designate as your attorney can do almost anything with your money and your property that you can do, unless you put limitations on them. All right? So this includes walking into CIBC and doing transactions on your behalf, right? Signing checks, getting a loan, buying, selling, or leasing real estate, right? Buying consumer goods and services. So imagine you're almost duplicating yourself in another person, right? And with regards to your finances. And so you want this individual obviously to be someone you trust, right? And someone who has your best interests at heart and someone who you have informed, right? But there are some limitations. It's not, sort of a free-flowing document. You can't do everything. And so some of the things you cannot do is that the power of attorney cannot make or change your will. So they can't draft a will on your behalf or make any alterations to your will. That is solely something that you can do. They cannot make or change who is a beneficiary on your insurance policy or registered plan. So for all of you or any of you who have a life insurance policy, the power of attorney can't go in there and write out your nephew and add their best friend, right? That's one of the limitations on it. They also cannot make a brand new power of attorney for you, right? So they are bound by the provisions that are outlined inside the power of attorney, okay? And so in Ontario, there are 3 types of power of attorneys, right? There's a non-continuing power of attorney for property, right? This type of POA ends if you become mentally incapable. Typically, the non-continuing power of attorney is used for a limited time, specified time. For example, if you need assistance taking care of your financial affairs if you're traveling. So you hear these stories about you're going to Jamaica for a month, but you run a business back in Toronto, right? And you need someone to be here to do the day-to-day financial rigmarole. You would draft this non-continuing power of attorney, and you'd probably just make it for the month of December until January when you get that. Okay. Furthering that, the continuing power of attorney for property in Ontario, the continuing power of attorney is responsible for making decisions with regards to your property and finances if you are medically incapacitated. This includes paying your bills, managing investments, and even collecting any money owed to you. So that could be in the form of if you had a rental property and if you were collecting rent checks every month, they collect that for you. Now we transition from things that are dealing with property and finances to the power of attorney for personal care. Okay, and this is, you know, when you watch the soap operas and the person's in a coma and they talk about pulling the plug, that's what power of attorney for personal care surrounds. But it doesn't have to only surround that, right? And so this individual can make decisions regarding your health care, housing, meals and clothing, essentially anything related to your personal care. This person is the voice of your healthcare decisions if you are unable to communicate for yourself. So that's why I brought up the whole situation where you're in a coma, because obviously if you're unconscious, you're not able to tell the doctor what you want them to do, right? They are also responsible for communicating life support measures, as I mentioned before, and other advance directives you have outlined in your will and POA documents. Typically, your power of attorney for personal care is a spouse, relative, or close friend who is familiar with your wishes and has good judgment. Circling back to what I said, you want someone who has common sense, you want someone who you have a relationship with who knows you well, who knows the conversations you've had, who knows that you've said, no, I don't want a blood transfusion. Those are the individuals you want, because obviously they're the ones who are going to execute this because you're not going to be around or you're not going to be capable. Okay, we mentioned a lot of this, right? It's kind of redundant here. Right. Okay. So all of this has been mentioned before. So we can. One key point that I do want to bring up is something called capacity, right? And so with the power of attorney, especially the ones that are specified where they are only to kick in when you are incapable. Well, what does incapable mean? I use the extreme example of you being unconscious. So obviously in that situation, you wouldn't be able to deal with your affairs. But sometimes you see this with things like mental health, right? Which is obviously a hot button issue these days, right? And so when we use the word incapable in this paragraph, who determines that you're not capable, right? And so sometimes you write into the power of attorney that the individual cannot start making decisions until they confirm that you are not capable. How do you do that, right? And so you see some language in here that sometimes I'll draft in the POA that sort of your mental capacity will have to be assessed by a third-party individual, right? And so sometimes we leave it up to the family member, but they're not a professional. How can you tell if someone's not really all there or they're not making proper decisions? And so in some of them, I'll write a clause that states that you have to get a third-party capacity assessor, and this can be a social worker or a doctor or a psychologist, and they'll do an assessment on the individual, and they'll draft a document that pretty much states whether or not you have capacity or not, right? If you don't, then the POA will, the power of attorney that you have designated will kick in, and they will make the decisions for you, right? Okay, so we know what a power of attorney is. Now we have to sort of go into the mechanics of what entails drafting one, right? And so the formal requirements of a valid power of attorney is that you can create a POA if you are of the age of 18 or older for a POA for property, and 16 years of age or older for a POA for personal care, and mentally capable, right? So again, an individual who has been deemed to not have capacity, right, would not be able to engage in this type of document, because the idea is obviously that you don't understand or what's happening and can't appreciate, right, what the power that you're granting in another individual. And again, that circles around issues with mental health, right? And so I have a little acronym here, WSW, right? So you need all of this and WSW, which is that it must be in writing, it must be signed by the grantor, and it must be signed by 2 witnesses. And of course, this is, sort of a guard against anything untoward's happening, right? And so you want the 2 witnesses because you want individuals to attest that they saw this take place, right? You want it to be signed by the individual to show that that was their wishes, and you don't want word of mouth. You want it in writing. You need it in writing. It's a formal requirement, okay? So WSW, if you want to use that acronym, that's helpful for me. Okay? These are formal requirements for the individual themselves. So one was for the document. This is for the actual individual, right? And so anybody witnessing or dealing with this document can be anyone except for your spouse, your partner, child, or someone you treat as your child, such as a stepchild, right? You can't have the power of attorney be the witness, right? It has to be a separate witness. So essentially, there's like 3 people in the room. There's you, the grantor, and 2 other witnesses who are not on this list, right? The witness cannot be someone under the age of 18. Cannot be someone who has guardian of property, right? Has a guardian of property for themselves, who's not mentally capable, right? All of those things surrounding. Basically the same rules as someone who can get into a power of attorney cannot be one of the witnesses, right? So we went over sort of how it begins, and then this is how you can revoke it, how the power of attorney would come to an end, come to a conclusion, right? And so in order to revoke the power of attorney, you must sign what's called a notice of revocation, okay? And that is a document that says you cancel your POA or are drafting a new POA. Those are your options, right? And language in the new POA, and all of my POAs that I draft, is that there will be a language that says this power of attorney revokes any previous power of attorney, and then we just go based on the date, right? Whatever is the most recent date is the one that wins out if it were to ever be challenged, right? Another formal requirement is that the witness must also sign the document, and all 3 of the individuals, the grantor and the witnesses, must be together while this happens. So it can't be that you sign it on Monday and then the witnesses sign it on the Thursday. And the reason for that is, again, for everybody to be in the room assessing the situation. I think I see a question.
Yeah, quick question.
Yeah.
When we're talking about being in the same room, what about when it comes to DocuSign and electronic? Is it kind of the same way?
Right. So good question.
It has to be the same date or same.
Right. And so a good question with that. And the short answer to that, in the event of COVID, a lot changed, and a lot changed very quickly, right? Meaning that obviously during COVID, sometimes there are people who are on their deathbed in a hospital and could not obviously be in the room with everybody else, right? Remember back then? We don't want to remember back then. We were all separate, right? And so the legislation came in that allowed relaxation with regards to online or electronic signing, right? For situations like that, right? Where it would be a Zoom call and then people could just DocuSign, right? But even with a Zoom call, although you're not in the room together, best practice for me is that I can still get everybody in a room together, right? It's still a virtual room, right? And so what I do is I arrange for the virtual signing, right, with everybody. We all get on the virtual call, right? And I explain everything to everybody, and then I send out the documents, and to your point, they click with a DocuSign, right? Again, that's a very fluid area of law because there's a propensity for fraud in those situations, right? It relaxes sort of the hard line rule, right? And so again, that's a further conversation. I think different lawyers are doing it differently. For me, when at all possible, I want everybody in the same room, right? I'll get to your question. I'm almost finishing my sentence, and the reason for that is because of the fraud factor. And in the room, I can sort of see how you're projecting. I can see sort of, are you fidgeting? I'm not a psychologist, but I can do a mini capacity assessment when I meet with you. Virtually is a lot more difficult, right? And so that's the answer to your question. Did you have, yes, go ahead.
You mentioned 3 people in the room, yourself and the 2 witnesses. Does the power of attorney that you're naming not have to sign to accept this responsibility?
No, and so it's a good question. That's a question you want to have with the power of attorney, right? And so if I want to grant you as my power of attorney, and you're like, no, I don't want to do that, right? Well, you pretty much told me that you're not a good candidate, right? And so the reason why the power of attorney has no say in it is again, circling back to fraud or duress, right? If I wanted to lean on my old grandma and say, hey, grandma, make me the power of attorney so that I can have access to your millions of dollars, right? If I was one of the signing authorities on that, that would be kind of untoward, right? And so the person who is the named power of attorney has no role in it, to be quite honest, until they are named, right? And then once they are named, they can execute whatever the power of attorney allows you to do, right? So great question. You have a vested interest in the outcome of the power of attorney, so they don't allow you to be one of the signees or the other witnesses. That's a great question. Any others before we go forward? Okay, great. Okay, so we went over all of this and the reasons for it and how you would have revoked the old power of attorney, right? If you want to draft a new one. Okay, so we're shifting now from the power of attorney world into the world of the will. Sorry, did you have a question before we go?
Last question about power of attorney.
Yes.
Does the power of attorney override that wishes of the spouse?
In terms of like day-to-day finances,
Right.
yeah, absolutely, right? Which is why, for the most, I'd say 9 times out of 10, the power of attorney is the spouse, right? Because to your point, there could be a conflict there, right? So I don't know if I recommend it, but just in practice, what you see is that, like I said, 9 times out of 10, it is the spouse, because that's the person that's closest to you. You hope that's the person that has your best interest in heart. However, there are situations where that's not the case. There's situations where a client will come into my office and they're like, sir, I want to make sure you don't call my husband, okay? You don't let him know. I'm like, no, you're my client. I'm dealing with you, right? I don't want him to be in charge of this, that, and the third. And so, again, this is circling around. It's your wishes, right? We want to make sure we reflect what you want, the person that you trust, and there is conflict. There are many wills and power of attorneys that are challenged by spouses who are not designated as the power of attorney, right? And then that goes to court, and you show your documents, and I show my documents, and you make the case why you should be the power of attorney, and I make the case why I shouldn't. But the guiding document, I would say, that would win out more often than not is whoever the grantor designates as their power of attorney. It's not a default provision. Now, absent a power of attorney, it would likely default to a spouse, right? And you'll see that when we go into wills. Absent a will, certain things are going to happen, right? But the reason why you sign these documents, it would be difficult for a judge to overturn this because I'm showing you a document that shows what the desire of the grantor was at the time of signing. What's the counter to that, right? I have this document. They had their capacity, right? They wanted it not to be their husband or wife. They wanted it to be their best friend from college. What's the pushback to that, right? It's going to be a very difficult hurdle to get over if you have the signed power of attorney. Great question. Legal question. You're trying to stump me, but I appreciate it.
Do you still have a question?
No, it was answered. It's the capacity of the person granting that power of attorney because it's before they deteriorate to a point where they can't make a decision. So I was just saying, like, if you're struggling with making decisions, who's to trust that your decision is the best one to grant someone else the vote,
Right.
as opposed to the spouse.
Right. And so, like I mentioned, I'm not a psychologist, but I like to sit down with the individual, right? And I'll ask them just qualifying questions. You know, what brought you here today? If the client answers that, well, my daughter really told me I have to do, that's a red flag, right? I want it to be like more like, you know, well, you know, it's been a long time, and I really want to have these assets, and I really want to, you know, make sure my family's taken care of. That's a green flag, right? Or I'll ask them, you know, okay, well, what do you own? You know, what property? If they ask, well, I don't really know, you know, I have the house in Jamaica, and I think I have a property. That's a red flag, right? Because what do you mean you own 3 homes and you don't know where the address of the home is or what you have in the bank account, right? That to me shows an individual who doesn't has a grasp of what they're granting in another person, right? But if they're quick to be like, oh yes, I have a bank account in Nova Scotia and an account in Cayman Islands, that person is on top of it. And that person, again, I'm not a professional in that regard, but just by having a simple conversation and asking them a few questions, I kind of get an idea of where they are in terms of their capacity. And if it looks like, you know, the nephew is standing right next to grandma, come on, grandma, a red flag, right? That's like you're leaning on them, that's duress. At that point in time, I might ask, let me meet with grandma on her own, without the family around, right? And then I can get a better sense, like, hey, is this what you want to do? And then sometimes they're like, no. Sometimes they're like, I'm getting a lot of pressure from my family, and in that case, I shut the whole thing down, right? Because this person obviously
Undue influence.
so there's undue influence here, and there's ways, you know, to your point about what document wins out, that would be a way that these things would be challenged, right? Like, so even if I had a valid, signed, executed power of attorney, if there was evidence of fraud or undue influence, it wouldn't be worth the paper that's printed on it. And so I think a good lawyer anticipates that and anticipates the dynamic sometimes in these situations and gets out ahead of it, right? Because I want to be able, when I'm dragged up on the witness stand 13 years from now, right, for them to ask me, well, what was the situation? I don't want to be able to say, well, I don't know. I just signed the document and I just did whatever they asked me to do. I want to be able to say, Your Honor, my practice is that, you know, I go through this checklist, and I remember that day I had some notes here, and I asked, and the person seemed to have their wits about them. That's a better answer than just saying, like, well, yeah, I did whatever the person told me to do. Yeah, again, not necessarily required by the law society to do that, but I find that to be the best practice. Hopefully that answers your question, sir. Great question. Did you? I saw you raise your hand.
I did, but I don't know if it really applies. It was about having an interpreter. Because
Right.
you were mentioning like the grandma with the nephew.
Yeah.
You know, a lot of times it might be that they just don't have a good sense of the English language to communicate.
Absolutely, that's part of it too, and that's why I try to use layman's terms, right? Like conversational language, right? So sometimes there is that language barrier. Like I'll say, you know, I won't use words like, you know, domain or property. Where do you live, right? But if there is that sort of disconnect, I might ask, like, oh, where are you from? I'm from Mexico. Would it be helpful if you had, you know, if you could find someone in the office who can speak Spanish or whatever for you? Because you are correct in the sense that some people are leery or hesitant to engage in conversation with professionals or whatever because of that language barrier. So it's a great point. I think best practice would be, depending on the size of your firm, my firm's not that huge, right? But if you had a Mandarin interpreter, if you had a patois interpreter, as they have in criminal court these days, believe it or not, they have that. It is very important, I think, with that language barrier. What you want to do is establish sort of that rapport with the individual, right? And so that they feel that they can, you know, confide in you and trust you. What I don't like is when I see someone guarded, because then that is, again, avenue to duress and fraud and undue influence. Okay? Great questions. Thanks, guys. That shows that you're engaged, and that helps me out. Okay, so moving on from power of attorney, and again, we don't have to move on permanently. There'll be a Q&A session afterwards, but we're going to from the, you know, I call it the living document when you're alive to now you're gone. You know, knock on wood, 100 years from now, you've passed away, everybody, and now you can't. There's nothing you can do, right? And what happens with regards to that? And so, when you die without a will, it's called you die intestate or intestacy laws, right? And so we're going to delve into sort of, and the reason why I go over this with this group is to obviously show the importance of having a will, right? If there was no consequence to not having a will, then we wouldn't be here today, right? You just take your chances, okay? Again, we have our Turkey friends, and it says, James did not leave a will, but he'll still be able to help determine which of you gets his inheritance. And he has the wishbone there. So you want to avoid that. You don't want to make a luck of the draw, and whoever breaks up the wishbone gets the house. You don't want to leave it to that, right? You want to make sure that everything is outlined correctly, all right? So what happens if you do not have a will? Okay? These are a few things, of the many things that could possibly happen, right? Firstly, your estate may not be divided how you want it to be. That's just pretty obvious, right? Instead, the court will decide who becomes the caregiver of any children or property you may have. That's another negative. It also presents financial and emotional difficulties for your spouse and family, especially for those who are in common law relationships, and that's a big point. So first of all, like I said, you've got to paint the picture. You're deceased, your family is distraught, they're sad, they're devastated, and then on top of that, you didn't have a will, right? And so now what do we do? And then you thought you were on the same page, but grief is a funny thing. People deal with it differently, right? In the sense that some people are calm, cool, and calculated. Other people are resentful, angry. It brings up a lot of emotions. You want to try to avoid that for your family, right? You want to outline exactly how it is, and it can act as a tiebreaker. Instead of using the wishbone, you're using this document that, hey, this is what mom wanted. This is what dad wanted. This is what my husband wanted, right? And then for the common law relationships, the reason why that's valid is that there's always interplay between different areas of law. So family law has its own mechanisms that happen upon the death of a spouse, for example, a married spouse. And those provisions don't necessarily protect or apply, is probably the better word, to common law situations, right? And so you might be living with someone for 35 years and think that, hey, this is how the law is going to see this, and be very surprised when you get to court and it doesn't have the outcome you want, right? And so just avoid all of that, right? Just have the will that outlines exactly what you want to happen in the event of you passing away. Did I hear a question? Sorry. Okay, good. Also, other things, a missed opportunity for any charitable donations. The government's not going to give any money to the church or to the Humane Society or anything like that. Like I said, what they're hoping is that it all comes back to them, right? And so you would miss the opportunity to give any sort of those charitable donations. And then finally, practically the time it takes to close your affairs may take months and even years longer than if you had a written will, right? Because then you're going to go through their process, and the government is a slow institution, right? So this is just a few of the pitfalls, right? Here's another one. Question for you, Helena. A rich man dies leaving no will. Which of his relatives gets the money? I don't know. None of them. Don't they teach you anything at law school? Well, who does get the money then? We do. That's the lawyer, the greedy lawyers, right? They're sitting down there because they get to, and what that means is that we get to litigate, we get to go to court, and we're going to charge the estate. So we're happy when you don't have a will, right? And so here's a lawyer, I'm telling you this against my own self-interest, right? I'm telling you this, taking money out of my pocket, right? And so pay the upfront fee, and so you don't have to pay me later on when we go to court and have to fight, and everybody's going to lawyer up, and there's going to be 17 different lawyers, and you want to avoid them. Don't fill these guys' pockets, right? Okay, and so we spoke about sort of dying intestate and what happens. And so the Ontario uses the Succession Law Reform Act to distribute your estate if you die without a will. Remember, you died without the will, the government steps in, they use this legislation, and there are certain rules that apply. So I guess if you love the rules, then don't get a will. If you're okay with the way the government distributes your estate, then that's fine, right? But this is just a few of the points as to what they do, and it's very exhaustive. Like if you were to read the SLRA, it's many, many pages long. And so this is just I tried to distill it as best as I could to what I thought would be relevant to the crowd, but there's many more ways that this can play out for you and different permutations that can happen if you were to die intestate, right? So first, if you have a surviving married spouse, right, and no children, your spouse receives your entire estate, right? So we mentioned that with the POA, but now we're in the will section. Yeah, okay, in that situation, in that unique situation, that's what would happen, right? Is that what you want to happen, right? That's up to you. If you have a surviving married, not separated spouse, because again, and that's the reason why that's important. Your mind sort of races when you deal with these hypotheticals, because you have situations where you're legally married, but you hate the other person and you're separated, right? And this happens with life insurance, this happens with wills. Can you imagine being separated for 5 years from your spouse who you hate so much, but then you wouldn't find out, but your family would find out upon your death that their life insurance policy goes to that spouse? Or what you wrote in your will 17 years prior, that they get the Lamborghini and they get the boat and they get the yacht. Can you imagine how angry your family would be finding that out, right? So that's why they bring this caveat when we talk about who's not legally treated, separated. That has everything to do with where are you in your relationship? In our community especially, West Indians, I don't think we divorce. We just walk away from each other, and people have been married for 45 years. And on paper, they're still married. And you're like, well, I haven't been with him for 45 years. You're like, but I have the piece of paper here, right? And so it's a legal document, everybody. And so you need to understand the concept that just because they're not in your house doesn't mean there's not legal implications, right? So anyway, sorry, I went off on a little bit of a tangent there, but I think it was germane. If you have a surviving married, not separated spouse, and one child, your spouse receives the first $350,000 of your estate, which is called a preferential share, and any remaining amount is divided equally between your spouse and your child. So is that what you guys want? I don't know. It's up to you, right? And so on and so forth. And we don't have to go through every single last one of them, but it sort of just gives you the outline of if you have one child, multiple children with grandchildren. We can see it gets really messy and very complicated, right? And it might not be something that you want to have to worry about. You might just want to tell us what you want to happen in the event of your death, right? I think that's the easier route. But if not, the government has you covered, okay? Again, there's more. Again, it's a long, lengthy legislation, but if you do not have a surviving spouse but have children, it's divided equally among your children. If any of your children have died before you, that child's share passes to their children, your grandchildren. Right? We can't keep up with all these grandkids and parents and things of that nature. Any questions? Oh, sorry. Yes,
I
go
was
ahead.
just waiting to see if public. So there's no provision made for common law spouses who've lived together for so many years and have or don't have children?
They do. Again, that would be would have to review the Succession Law Reform Act more closely. There is provision and what happens, and I can tell you what happens in practice. You just end up in court. That's the more likely path, right? Because like I said, you don't get the automatic protections under family law or estate law that you would get in a married situation. I mean, that's sort of the downfall, right? Like, to the average person, there is not a big difference between common law and being married, but in the eyes of the law, there is a very big difference, right? And so, not that there's not any, that would be a further conversation to sort of see what the situation is. How, do you fall under the definition of common law? Some people think they do, right? I think it's now 3 years living together, or a child, right? You might think that you're living common law, and in some situations I've seen, it has to be, you live together for 2 years, and you broke up for 3, and then you live together for 5. There's sort of this discontinuation in the timeline, right? So that's where it gets, I don't want to give you the lawyer answer where I say it depends, right? But I would really have to take it on a case-by-case basis. The short answer I'll give you is that not that there's no provision, but again, let's not wade in the weeds with finding out what the provision is. That's just, you can make accommodation for your common law spouse in your will or in your POA.
Okay, I'm wrong, Sheldon, but in a situation like that, would they have a claim under the Family Law Act instead of the SLRA?
Right. So there could be another. We're not having the family law session
Right.
today, but there's other ways to attack it. I'm not saying you'd have no course of action at all. You come to me as a lawyer and you say, represent me in this situation, I'm going to find an argument to make, right? And so to the point, there's another avenue you can make under the Family Law Act, right? But then again, now you have dueling, you have your estate planning lawyer, you got hired a family law lawyer, and then even under the Family Law Act, like I said, it does not treat common law situations and married situations the same. It just outright does not. There's completely different provisions, completely different legislation that can be in effect. You'll have dueling and competing, and the judges and the lawyers are going to figure out which one trumps the other. And it, like going back to the other comic strip that I showed you, everybody else is getting rich off of this except for you and your family. And so, great context. Short answer: no. There's always going to be an avenue that the person can make a claim. Whether or not they're going to be successful on that claim is the question. Right? I tell clients all the time, oh, I want to sue this person. You can sue. Are you going to be successful in the lawsuit? That's always the determining factor. All right? But you know, this exercise is already beneficial because your brain is firing, right? You're thinking about all the different situations where common law, married, one kid, grandkids, no kids, stepchild, right? All of these different things is sort of why these conversations are important, right? Yeah, I want to just mention the last paragraph. I always like to talk about the government. If you don't have any of these relatives listed above, your estate will pass to more remote next of kin in accordance with the degrees of relationship set out in the SLRA. And if no next of kin can be identified, your estate ultimately, again, goes to the government, which is what you don't want. Okay, so I think we've established why a will is important, right? No? Because if not, we can shut it down right now. No. Okay, so that's good. So what is a will? Sort of touched on it, but I think this video, in a humorous way, sort of outlines what goes along in the process, right? And so, if I could have my trustee.
Hey! So, y'all can do all this renovation work and you still can't call the estate planner that I connected you with?
See, we knew you were gonna ask, so. There you go.
Y'all wrote your will in pencil?
Well, I had to erase a few things because Jerome pissed me off.
Mom, Dad, this limp, loose leaf of paper does not qualify as estate planning. You actually have to go through lawyers.
Hey, Molly.
Okay, so I'm glad I heard the laughing from the audience because that lets me know that we already know what the requirements of these documents are. It can't just be a little piece of paper that you wrote in pencil and all of that stuff. It needs to be more formally thought out. Another part about that video that I like, that I see in practice too, is when the mom sort of said, I want to write out and pointed one of the relatives that they don't want in their will. And you see that happen all the time. In practice, we have one client who seems like she comes every month to update, to update her will, and some nephew got her mad, or some niece didn't go to the college she wanted her to go to, and she writes them out the will. And again, it's good for us because she keeps coming back and paying us to redo a will. But some people use it as a weapon. I don't recommend that, obviously, but I like that part of the video where the family thinks they're doing the right thing, but they're not, right? And so we mentioned, in contrast to the POA, you can think of the will as a form of life insurance, which takes care of your loved ones when you pass away. It's a document that sets out the person's wishes and directions with respect to the disposal, again, not throwing away, but just passing off of their property after death. Again, we have the language and definitions of the testator, which is the person who makes the will, and to execute, which means when the testator signs the will. Okay? Who can make a will? Very similar to the power of attorney, right? To make a will, you must be mentally capable. That means you understand why you are making a will, the nature and amount of property you have, which of your dependents should be included as beneficiaries. That's why I remember I had mentioned when I asked sort of the qualifying questions, I asked you sort of, well, what kind of property do you have? Because it helps me determine whether or not you have the mental capacity, right? I mentioned this before. Your will may be challenged if it is made when you are not mentally capable, or if you do not include dependents, right? A dependent is a person you were supporting financially before you died, or a person the law says you must support, right? And so that's actually a good place to sort of pause. When clients come in and want to write their son, who they are upset with, out of the will, I have to advise them first of all. And then secondly, I have to put very clear language that the person really understands what they're doing, right? So it's almost like an added, it's not just the fact that we're leaving the dependent out. Because what will happen is that the person will pass away and the son will challenge the will. Like, no, my dad would have left me something. Something must have happened. And best practice for me is that I write the clause in the will that, the client fully understands that they're not allowing Sheldon to be one of the beneficiaries. And the reason for that is because he, burnt down the house when he was 18 years old, right? And literally put that in there so that, again, you got to be forward thinking and think when it's in front of the court. No, Your Honor, the person appreciated why, they understood they had a dependent, and their desire was to not have this person be a beneficiary under their will, right? And so it's very important that you are clear with that type of language. And so it says your will may be, I would say it's almost your will be. If you write your son out of the will, they're going to challenge it. But you want the will to be written and drafted in a way that is very clear that you did not want your son to be your beneficiary under the will. The author of the will must also be at least 18 years old, but there's always a catch, right? You can be younger than 18 if you are legally married. I guess it wouldn't apply to common law situations, I don't think. A member of the Canadian Armed Forces. The reason for that is that you had young people going off to war, and you wanted to give them the ability to get their affairs in order. And I always like this one, a sailor. This is dating back to maritime times where people were going across the Atlantic, and a big storm came, and they wrote down their will, even though they were only 17 years old, because we wanted to give them the opportunity, right? So these are people who can make a will. Formal requirements of the will, very similar to POA again. It must be in writing. The will must be signed by the testator. The will must be witnessed by 2 witnesses, neither of whom can be a beneficiary named in the will or a spouse of such beneficiary. This circles sort of back to your question with regards to could the power of attorney be the person? Well, in the will, the beneficiary can't be one of the witnesses. The spouse cannot be one of the witnesses, again, for duress purposes, right? And undue influence and fraud. So, we've established that we need a will. We've established sort of what goes into drafting and the formal requirements for the will. What are some of the things that should be included in the will? Your will could include beneficiaries, assets, and debts. That's a key one. In all of the provisions, in all the wills that I draft, there is a clause that states, people don't think about this, but when you die, you might not be coming into this money. You might be indebted, right? And so, depending on how large the estate is, right? If the person owes $1 million and they only have $300,000, that's $700,000 in debt, right? And so there's provisions in there that instruct the estate trustee to pay off any sort of outstanding debts, right? I'm getting an alert from my people that we should take a quick break right now. So this is actually a good place to take the break. So I think there's snacks and stuff available. Let's take a 5-minute break, 10-minute break, and get all of your provisions, and we'll come back and finish off what should be included in the will. Okay? So we were speaking about provisions that your will could include, right? And so we spoke about your beneficiaries, obviously, any assets or debt. We went into the sort of how important that is. Custody and guardianship clauses, right? This is dealing with minor children, right? Again, you got to think about if you have young kids who you want to step in your place, right? The law sort of is back and forth with your grandparents and whomever, but it would be nice if you could outline. I remember my parents had, when we were younger, my mom had designated her sister to be our guardian, our legal guardian, as long as we were minors. And so that's things that you want to start thinking of. And then who you want to be your trustee or executor. It was brought up before that, you know, you want to pick someone who you've had a conversation with, obviously, and is willing to do it, right? The last thing you want to do is have a situation where you just pick a random person from work and you haven't spoken to them, and when the time comes, you're like, oh no, I don't want to be the executor, right? You need to have a conversation with the individual. At our firm, because obviously there's some people who don't have family members or friends that they trust, and so our firm does provide the service that we will be your trustee or executor, right? Obviously for a fee, but the person sort of obviously we're well versed in how to execute any sort of estate, right? And so that's also an option for you if you don't have any family members or friends that you would trust with such a difficult task.
I love you.
Okay, so let's just get back into it. So we covered beneficiaries.
Oh, and Kiki sent you an email. She wants all of my linens and my anklets.
Yeah, I got that email. I also ignored it. So why don't we just go back to balance sheet?
Balance sheet? What's the balance? Y'all know you get the house.
We made sure of
We
that.
still gotta discuss the specifics, like how are we splitting the house, and what's in your set, or do you have a raw? And if mom has another stroke, where does her money go?
Ooh, we have not talked about that.
Y'all want some tea? I'm gonna make some tea.
This sound like a lot of questions which lead to the same thing. Just split whatever there's left evenly. I don't care. I'll be dead.
David.
Dad.
You know, Mr. Carter, I know what you mean. You know, but the bank's gonna need an actual dollar amount so they can paint an accurate picture of your financial assets.
So how big is the 401k?
I had to borrow against it to cover your mom's medical expenses. There's not much left.
Wait, what?
What happens if mom has another stroke?
I don't like this conversation.
We're out of tea. I don't know if we ever had any tea, but I'm gonna go to the store.
I promise you, Mr. Carter, nobody likes talking about money. And when you see your whole life on a piece of paper, I mean, it's sobering. I can't tell you how many of my clients I've seen open mouth sob because all they have to pass on is an old Nissan Sentra. Manual transmission. But we're professionals, and I've seen every scenario under the sun.
I just don't like seeing how little I have to leave my family. I mean, I worked 50 years and it feels like I've got nothing to show for it.
That is not true.
Dad, you gave us love. And that's what's most important. All of this is just things.
And, you know, it's never too late to start saving for your grandkids. I mean, we could hook you up with a special savings account today. All we have to do is call the bank, and you know banks love getting calls. Answering phones, always like, hello?
They do be like that.
Look, we can just take it one step at a time.
You trying to make a withdrawal?
So I like that scene because it has everything, right? It rolls everything that we're talking about. You know, the awkward conversations, the fact that especially in our community, we don't like talking about death, right? It's almost like you're speaking it into existence. You had that guy who kept on going back and forth with avoidant behavior, but with tea, right? You have that sort of, there's a lot of different ways people can react, right? There's difficult conversation with regards to, you know, the family just finding out that the father had borrowed against his 401k to help the mom with the medical bills, right? You saw other instances where they didn't want to speak about the mother having a stroke because they didn't want to speak about it, right? And so I love that scene because it has everything that we're talking about all tied up in it. But these are important conversations to have, obviously, right? Not always the easiest conversation, but I like the point, I think it was the young woman who was sitting on the couch saying that we're professionals, right? So we've heard it all. We've seen estates that are in severe debt, and we've seen $1 million estates, right? And everything in between. And we've had conversation with people who are crying on the phone, who have all the range of emotions, are angry, whatever. And so don't feel, although it's an awkward conversation when you meet with a professional, they've already heard probably much worse, and their job and their role there is to guide you through the process, right? Even though as difficult as it may be. So I hope that sort of resonated with people inside the audience in terms of how this process can go, right? Did you have a question, or were you just agreeing with me?
Oh, no.
No, okay, that's perfect. Good. All right. So we mentioned all the things that can be inside of the will, right? And so we mentioned custody and guardianship clauses. If you have minor or dependent children, you will want to make sure that you make arrangements for them if you pass away. And so we draft what's called a custody clause. And so when you're thinking about the custody clause, decision-making responsibility, right? Do you want the kids to go to a private school or public school? Do you want them to be in karate or taekwondo or anything like that, right? Another big one is children with a disability, right? That will be a difficult situation where you want to make sure you have provisions and outline exactly how you want that child to be taken care of, right? Which may stretch past the general 18 years, right? Some individual with disability, it can be a lifetime situation. Oh, I don't know why you're flagging me. Some of the questions when we were during our break were surrounding just sort of the interplay between, I'll call them various factions, right? Because you have an individual who will come in with sort of a situation where they weren't the original parent, but now they have guardianship of the minor child, right? And all the different permutations and implications of that, right? So when I'm going through these assessments, right, I'm trying to verify, validate. An individual's coming to me and saying, oh, I'm the guardian for a minor child. I have this will, right? I'm the power of attorney, this, that, and the third. I don't just take the document and say, okay, cool. I do a little bit more digging, right? I say, okay, where are your guardianship papers, right? Show me that documentation, because all of that would have been documented. And then I confirm, right? Because when you're dealing with minor children, obviously they can't advocate for themselves, right? So you got to make sure to do an extra layer of due diligence and search when it comes to those type of situations, right? So very, very critical when you have minor children to make sure you have these provisions clearly outlined. Disposition of property is another comment. One day, son, 60% of this will be yours, right? He points to the house on the hill, right? The son's like, what are you talking about, Dad? Right? And so disposition of property, this is another very important part of the will, right? There's a clause in there that instructs how an estate is to be distributed amongst the beneficiaries. This is an essential clause because a will is not considered a will unless it contains some form of disposition. This is very important. You're not just drafting a piece of paper just because, right? There has to be a movement of property or assets from you to another person, right? Or we're not really talking about a will if that's not the case, right? And so what would that look like? Real estate. And key things to remember, even if you don't own real estate when you're drafting the will today, you might own it in the future. You might be the beneficiary of some property from someone else's will, and then you have a home, right? So you got to sort of be forward thinking. We can't redraft this will every single day for the rest of your life. We have to sort of have some common sense clauses in there that deals with property in the event that you may have it, right? Other things that surround property, personal effects and household furniture, right? You heard the lady in the clip talk about her linen set and her anklets, was it, or some sort of jewelry, right? And so you see these things all the time. They're a baseball card collection, they're a stamp collection, they're antique collection. Some of them are hoarders, and they have all sorts of things that may have value to them, but doesn't necessarily have value to anybody else, right? But you want to put anything like that in there, right? And so the way it works is that any property that is given as a gift must be retained by the estate trustee until delivery to the beneficiary. So in that clip, the estate trustee would come in and hold the woman's linens and contact the person who is the beneficiary and deliver the linen to the beneficiary. That's how that works, okay? Other personal effects and household furniture, appliances, and equipment can either be sold or distributed to the beneficiaries. And that is at the purview of the estate trustee to make that decision. Other things like vehicles, cars, right? If they own a vehicle, it's the estate trustee's duty to take possession and keep it in a safe place until it comes time to transfer it. Building assets. Anything you could think of that falls under the property realm, right? That's what we're dealing with here. Okay, so trustee or executor. An executor is a person in charge of taking care of your estate. Much like the power of attorney, you want to make sure it's a person who's competent and wants to do it. If you do not choose one before you die, the courts will be in charge of appointing an administrator to execute your wishes. And this person may not be someone you wanted to act in this capacity, right? The responsibilities of the executor are to pay off estate debts, like I mentioned before, recovering any money owed. This could be like rent due, or people who owe you money, they could be your loan shark and go out there and collect on your behalf. Paying your final tax return. What do they say? There's two guarantees in life, death and taxes. So here we go right now, that upon death, there's still tax implications, right? Distributing assets and your gifts to your beneficiaries, handling your funeral and burial wishes, including the organization of your funeral or cremation, right? The executor and the estate trustee are two different roles, but the same person can fulfill them, right? It's kind of a little bit of a semantics game. On most of the wills, I just put one and the same, executor and estate trustee, unless the individual advises me otherwise. The main difference is that the executors take care of the entire estate administration process, and once that is completed, in typically 12 to 18 months, their role concludes. So again, treat this person just like you would treat the power of attorney, someone you trust, someone who knows what you want, and probably even more so than the power of attorney, someone who's qualified, right? Who's a business mind or a finance mind or a legal mind, who won't be overwhelmed by the different type of conversations they're going to have with the government or the banks or whomever. Again, with the semantics game between the trustee or executor, a trustee would only handle the trust, assets that are being held for anybody who has been under the trust, and work with them, the named beneficiaries in that trust, right? And so if you have minor children when you pass away, many wills trigger the creation of what is called a testamentary trust, right? And because in the interest of time, normally this is like a two-part presentation, but we don't really get to delve too much into trust today, right? That could be another conversation for another day. But as I want to bring it up in the sense that we can draft the will in a way that creates these things called testamentary trusts, right? Which hold assets in trust until the age at which you stipulate in your will, right? So that's a situation where you have a 4-year-old, but you want to create a trust for them to be able to go to college, for example. Right? So you're setting aside $80,000 for their college fund, but obviously you're not giving that $80,000 to a 9-year-old or a 5-year-old, right? So the trust will be created. You have the trustee who manages the trust up until that point where you stipulate the child turns 21 or goes to college or whatever, and then you give them their money. While the executor's role ends as soon as the estate administration process is complete, a trustee may act in that role for a much longer period of time, just like I illustrated. A young person, they're not going to college till they're 21, they're only 5 years old now. We're talking about many, many years that the estate trustee might have to be involved, as opposed to the executor, who is only involved up until the estate going through the proper channels like probate. Okay. We are at the point with questions. I know many of you came to me during the break and had your questions, so don't be shy, right? Before we go to questions, I just want to say, like I said, in practice, you see the highs and the lows, the ups and the downs, right? We're professionals, we deal with it, right? There's never a dumb question or, you can write pretty much anything into these. I use some silly examples, but these are examples that I have seen in real life, like who takes care of the cat, right? Like that's a real provision. Like pets are very important to individuals, and they'll write that inside their wills. And so I say all that to say, don't let it be a daunting situation. What is a daunting situation is when you don't have these protections, right? I was having a conversation earlier that in our community, what I find to be unfair is that in other communities, they have their lawyer on retainer, they never get caught in these negative situations. But in our communities, it's almost like too little too late. Oh, my uncle died without the will, and now it's all falling crashing down on me, can you help me? And that route is just always much more onerous and much more expensive, to be quite honest, than just doing it this way proactively. Again, like I said, I'm taking money out of my own pocket, but the proactive way is always the better way, right, with regards to that, than having to deal with the issues that can arise with litigation. And don't assume that your family is going to act the way you think they're going to act when you're not there. I guess it's probably the best way I can put it, the nicest way I can put it, right? I've seen horror stories where multiple siblings are fighting over the remains of their parents. And it's just not, it would have been much easier if that individual had just done the very simple, proactive approach with regards to that. Okay? So with that, I'll take any questions from the audience. Yes?
Could you briefly explain you don't have to get too deep into it, but the tax situation with administration?
Right, and so again, like trust, part of the presentation had sort of probate and what different taxes surrounding that would be, right? And so I'll explain it in a nutshell, like you said, not to go too much into it, but by law, the probate process taxes, there's an inheritance tax, there's different types of fees that they'll charge you with regards to the disposition of your estate, right? Even with that, there are ways to avoid certain taxes, right? So there's something called a primary and a secondary will. And so the law allows you to place certain assets in one category and other assets in another category. The reason for that is, like you mentioned, with regards to estate taxes, they're taxed at different rates. If you put them in a secondary will, right, it's taxed at a lower rate than if it was a primary will. And those are reserved for things like, there's a laundry list of things that you're allowed to put in a primary will: businesses, secondary properties that are not your primary residence, all sorts of different things. But shrewd individuals understand that, right? Again, it circles back to our conversation about paying the tax man, right? Why would we want to pay the government more on estate taxes than we have to, right? If we can avoid it by just doing some proactive things. And so along that lines, there's different breakdowns into how much goes into different types of taxes. But like I mentioned before, death and taxes, the tax man will get paid. So you got to make sure with these situations that you're taking care of their income tax. If you're closing out the property, all property tax arrears need to be taken care of before you can even sell the property. Estate taxes, the implications on you if you're a beneficiary, and the inheritance tax. Are you a relative? There are different amounts that you can get as a gift. Could be tax-free, right? So a lot of that is, speak to your accountant. Lawyers we'll give you advice as to sort of what the outcome can be, but we're not crunching the numbers for you generally, right? And so you want to have in tandem with your financial advisor and your your accountant, right? That will have the interplay between what I do. What I do, it's not really, when I'm drafting the will, I'm not necessarily anticipating what the taxes are going to be. I can tell you how to avoid some of the taxes, right? And so that's why I mentioned things like the primary and secondary will, right? But, probably the accountant is probably the best person to deal with regards to that. Great question, though. Any others? Yes, sir.
Okay, so I come across some people that will say, you know what, I don't have much, so I don't need a will. How do you like handle situations like that? Because a lot of people come to me and say, I don't have much, I don't need a will. How do you handle situations like that?
Yeah, so in many ways, great question. Many ways. First of all, is it Scotiabank that has that tag, you're richer than you think?
Yeah.
It's Scotiabank, right? Yeah, and so first of all. Is it BMO? I thought it was Scotiabank.
It's Scotiabank.
Okay, yeah. So they have the tagline, you're rich, and it's a great line, right?
Yeah.
Like, it's along that same vein where I don't have much, I don't have whatever. And so, you know, that may be true. Obviously, anybody living in the GTA, if you own property, you're a millionaire, right? Because the average house value in the city is $1 million, right? And so anyone who has property, what are we talking about? Like, that's not even a question. But to your point, for the younger people who may not have property or see the value in it, again, I say forward thinking. You and I had a conversation, and I didn't bring it up at the beginning, but I'll bring it up now, that I saw a statistic that between the years of 2023 and 2026, which will be next year, $1 trillion of wealth will be transferred from the baby boomer generation, which I think some of them in this room are, right, to the next generation, the millennials and Gen Z and all those people, right? That's 1 trillion with a T, not billion, okay? So we're about to see one of the largest wealth distributions on Earth's history, right, in Canada. And that's Canada. In the States, probably like quadruple that or 10 times that, right? And so I say that to say, even a 21-year-old who is thinking that, I don't have anything, I have more debt than anything else, right? Do you have parents? Do your parents have a house? Do your parents have a stock portfolio? Because there's coming a time, again in the concluding next year, where $1 trillion of wealth will be passed on to the next generation. And so that has implications for financial planners, accountants, lawyers, right? And so, yeah, it might be the case that you don't have a lot now, right? But anything can happen. You could have a kid tomorrow. You care what happens to the child. You could get married next week. You could, hit the lottery, right? I'm just sort of freestyling the millions of different things that can happen, right? And so, and so there's that part of it, and then there's a part where you don't determine when you become incapacitated or when you die, right? And so it's that interplay between, well, how long are we going to wait? Is it until I hit the lottery? Am I going to wait until I get the big job, right? Sure, you can do that, right? But we're not the authors of the timeline, right? If the timeline happens, you don't know when the timeline happens. And so those type of things is the conversation I have. And if it's not the time, then you can try to wait and see what happens, right? Great question. Yes?
Would you be able to briefly explain what is a living will and maybe a deathbed will situation?
Yeah, so those are terms of art, right? And so, there were different rules as someone who was on their deathbed like you said, didn't foresee the need to have a will. I got in a car accident, now there's on their last leg, and the law had some sort of relaxation with regards to what happened in those type of situations, right? With the living will, that's sort of the theory that it's a living, breathing document in the sense that we spoke about things like trusts, right? And when trust exists in real life, but when does it kick in? It doesn't kick in until the child reaches 21 years old or until such and such a thing happens. And so that's sort of the theory behind the fact that although it only kicks in when the person dies, so technically it's a dead will, it has implications while the person's living, and it sort of moves on and changes, and there's provisions that become null and void, like the minor one is a classic one. When I told you about my parents who had one where my aunt would come in and take care of us when we're minors. Obviously, when we no longer were minors, that provision you could pretty much just cross it out because it was no longer relevant, right? And so that's sort of the understanding or sort of the doctrine of those type of provision. We mentioned in terms of inter vivos wills and all this Latin language, right? Those are just terms of art. Like I said, they're referring to the ability of the will to sort of be malleable and change over time. Obviously, even if I was to draft a will that was 10,000 pages long, I could not anticipate every potential outcome and permutation, right? And so in that regard, you do the best that you can. And what I advise for everybody, even for those who have wills, while I'm thinking about it, is that any major life event, you should update your will, right? And what is a major life event? You buy a house, you get married, you have kids, maybe even if you get that promotion, right? Because all of it has implications down the pipeline that you sort of want to be reflected in real time as best as you can. Great question. Yes, sir.
How valid are the wills that displayed in the video you show if it's signed by two independent witnesses?
Yeah, it's a great question. We sort of laughed at the little pocket paper that they pulled out because it was on a flimsy piece of paper. But technically, I could draft one right now on that piece of paper, have you sign it, have witnesses, and it would be declared valid. And so we laugh because it's kind of not the formal way. If I handed that to a client, they wouldn't pay the bill, right? They would be like, what is this nonsense? But technically, all the requirements are, like I said, in writing, signed, and witnessed. And so, it wasn't a very good will in the sense that it didn't really say much, right? The one that we showed on the there would still be holes and gaps, but if there were anything to garner, it doesn't have to be in any sort of formal way or use some special type of paper. No, and there is a will registry, and I actually wish the government would actually force everybody to register. Because it would help in a lot of litigation, right? Let's not even worry about is this a real will or which one was it. We go to the will registry. No will can be valid unless you register it. I think if I'm using my community hat, I don't know that if it's equitable, like in the sense that there's access to justice, and would that be an extra cost? Would you're making something that already has a cost, maybe more exorbitant? I don't know, right? But I like that idea. I've always said that I want legislation to come down where they force everybody to register it so that everybody can have access to it. If the lawyer's law firm blows up and you never see that will ever again, you can go to an online source. I think you know how it is. One day I think we're going to get there. Just like land titles, once upon a time it was a big room full of deeds, and now it's all electronic, right? And so I think in the future you'll see that as well.
Based on what you were just saying, the date on it is an important part, so it's the latest one.
Correct. Very important part. Maybe I should have added that in terms of the formal requirements, the date, right? And so, because what's going to end up happening is if you have multiple wills, the judge is going to be like, okay, which is the most recent one? And for the old lady who comes to my office and changes hers every month, you're talking about 12 different wills. We're going to say that all say 2025 on them. Right? But you're going to see January, February, March, April, May, June, July, right? And then, okay, yeah, I see one for November. Oh, no, there's one for December. And the most recent one wins out, typically, generally speaking. But you want to make sure dates are all over. You want to make sure it's, the original copy as much as you can. And so just sort of food for thought. The Law Society doesn't give us any direction with regards to keeping the will, right? But best practice is that I tell the client, we have the facility, we have the capability of keeping the will for you. What I do is I run off a photocopy of the will, so they have like a photocopy. It's not the valid will, because the original always trumps it. But at least they know what is in it. When the person untimely dies, they give me a call, I provide them with the original will, and that's how that is sort of done. In terms of best practice, because lawyers, what is bound by the Law Society is that we always have to pass the baton, right? And so if a lawyer was practicing for 40 years and they're retiring, they got to find a landing spot for the wills, either another lawyer or giving it back to every individual, like mailing it back to the original, right? And so it's just a fail-safe way. Some people have a safety deposit box at BMO. So they say, nope, I want to take my will. And I go, okay, it's well within your right. I'll probably run off a copy for myself because sometimes they go and lose it. And they come crying back, oh, I wish I told you should have left it with me, but I have a copy. And the courts will, I could attest that was a true copy of the original will, and that can sometimes work. And so there's different layers of protection that you apply to try to protect the individual in case that there's things happen, a fire or a flood or whatever. But that's a good question in the sense that the date is very important. It's going to be the most recent one that wins out, and the reason for that is, like I said before, the very first provision on the will that I draft says, this is the will of so-and-so, and it revokes all previous wills before. That's just the way it starts. Okay? Yes?
I know a lot of this is, it depends, but
Yeah.
can you continue to expand on the process as someone who's never gone to see a lawyer before?
Right.
You know, how much time do you budget for this conversation? What documents do you bring with you? Like, what's your money budget? Who should have copies? Or
Right.
if anybody should? Like, what does that look like for someone just starting out?
Yeah, so it depends. But I'll walk through the process. It's a great question, right? So you call me, say, Sheldon, you've convinced me. This is crazy. I've gone this long. I don't have a will. I need a will, right? And so we set up an appointment. Normally, I send a checklist. And the checklist is very in-depth. Sometimes I warn the client, like, it's not an exam, right? Even though it's very in-depth, it just helps me. It helps me get a snapshot of where you're at. It helps you. It jogs your memory and, oh, this is important. Yeah, that is important, right? It allows me to assess capacity, right? Because if you're, oh, what is all this? Getting frustrated, I'm like, okay, something's not going on right here. And what I think it does also is that it helps your executor or your state trustee, because in my checklist it'll have many things like all your bank accounts, even your international bank accounts, all your stock portfolio. And some people don't want to put that down on a piece of paper, but that really helps your executor get a grasp of what's going on. The worst case scenario is when they come in and they think, oh, you only had that account at Scotiabank, and realize that you have like a ton of things and the person's in over their head, right? So I give you that checklist, you fill it out to the best of your ability, and depending on, how old you are, you'll either want to come in person for a face-to-face meeting or we'll do it by Zoom. But the meeting will happen. During that meeting, like I mentioned before, I'm assessing the capacity, I'm seeing, is there any undue influence here, what's going on? If it's a couple situation, like I mentioned before, maybe I'm giving the opportunity for everybody to meet by themselves, because you really want it to be private. You want to be as open and honest as possible. Tell me everything. I don't want to leave anything for my son. So then now I can tell you, okay, well, why? Why is that? Well, he did this and that. Okay, so it's an emotional decision, because the way that this might be challenged is if you don't leave something for your beneficiary, this, that. So we'll have those conversations, those tough conversations. Normally, I say it's more than one. Sometimes someone comes in and they're very clear as to what they want, or they're redoing a will and it's not their first rodeo. But for a person like you who has never ever met a lawyer, except for me, before, I reserve the opportunity to have another follow-up, because sometimes, like in this, I'm asking you guys for questions now, but you're going to go home and be like, I should have asked them some question. That's going to happen in the conversation, right? And so we have that sort of back and forth. I have the option of having a secondary one, but assuming that's okay and you give me back the checklist, I draft a will, right? And then again, either virtually or whatever, I send it over to the client, and they're like, oh yes, this is perfect. This is exactly what I wanted. Or what does this mean? What is all this mumbo jumbo? And we go over that. So to your point about the process, you're looking at like 2 or 3 either Zoom or in-person meetings. And then on the day when we're executing it, it's easy, because by that time we've gone through all of the process. We've already vetted all the issues, and you spelled this person's name wrong, whatever, and now it's a perfect document. You're just coming in to sign, and the signing process takes a minute, right? I'll arrange for, I'm the witness. I have another lawyer or the law clerk as the other witness, because that removes all the conflict of interest and stuff like that. You come in, I say, hey, this is the exact same document that we reviewed before. Sign it, give you the copy, and you go on your merry way. And so that's sort of the process. And then there's not much follow-up. I mean, hopefully I don't hear from you for another 100 years. It goes into the cabinet and collects dust. And we use this special type of, to the point earlier about, type of paper. We use like will paper. And so the will paper lasts like 100 years. Whereas,
It's exciting.
yeah, when you bring out this other paper, like some of the old wills that were literally drafted in 1935, and they're falling apart, and there's dust, and you gotta see if you can read it. It's crazy. And so it's kind of an interesting, like, this document is not gonna, hopefully, is not gonna be needed for many, many years, right? And so that's kind of cool.
Quick follow-up.
Yeah.
Is something like account numbers and logins and passwords part of this process, or is that a separate?
Yeah, so in my checklist, I have a provision for that. And some people are like, well, I don't want it to fall in the wrong hands. I'm like, well, I'm your solicitor. It's not going to fall in the wrong hands. But if you feel uncomfortable, don't do it. But to your point, that's helpful. You can imagine you're coming in, you're the executor, you don't know what's going on, and this person has laid out everything for you. And listen, it's only everything up until that date, right? Like, obviously, it's up to you to update it or whatever, but things like passwords are very helpful. Like, how do I log into your bank account? Now I got to go down to the bank, and now I got to bring my power of attorney or my will to show that I'm the executor. It's another layer as opposed to just having it right there and being able to access it and close all those accounts. So that's why I think the checklist is important. I've found with certain clients it's a little bit daunting, and so I'm nice with them. I said, fill it out as much as you can, and we can have that face-to-face conversation, and I can get the information that I need in that in-person meeting. Yeah. No problem. Yes.
Yeah. What the price ranges from the POAs to the wills to the estates?
Very good question. And so it depends, right? And it depends on. I'll have a client come in, know exactly what they want. Say I only have one beneficiary, my daughter. I have no spouse. I have no other people. That will is gonna take me 25 minutes to draft, to be quite honest, right? And I'm available today. I just want to sign right away. That's in, out, no problem. That's the one client. Another client is gonna come in, like the lady I spoke to you about, and have 100,000 assets, stocks, foreign properties, Lamborghini. I'm not exaggerating. Like some of the provisions, like was 67 different beneficiaries. Humane Society, $100,000. Crawford Adventist Academy, $200,000. Like this line item, church, this Anglican church, right? So that's a lot more involved, right? It's a lot more involved. It's a lot more liability for me as a solicitor. What I mean by liability is that this is going to get challenged, right? If it's a situation where you have 35 kids and 85 grandkids, and you're writing half of them out, and you have 3 ex-wives, this is going to get challenged. It's not going to be today, but 10 years from now, I'm going to get hauled in front of court, and then it's going to be, I call them the gifts that keep on giving, right? And so this is going to be a file that's going to have ramifications down the line. And so I assess it based on, quite honestly, the amount of work it takes to draft the will, and B, the amount of liability that's attached to it. There's not much liability, to your point, the young person who has no assets, who's just, everything to my parents, right? That's different than the CEO of a tech firm who's coming in to do an extensive primary and secondary will on their entire estate. But to be fair, I'm not going to give you the full lawyer answer. There's a range, right? And so for the Adventists in the room, the conference actually provides wills for you for free. Free meaning they pay me, and you get a free will. For the private clients, it can range anywhere from, like I said, the very simple situation where you're looking at like probably $800 all in for the POA and the will, right? To there's not even a number, depending on how ridiculous it is and how long I'm gonna have to. I said it normally takes 2 meetings. Some of them take 9 meetings, right? Some of them I'm meeting with their whole family, and then trying to assess. Is this undue influence? Is it, what's going on here? The brother's calling me, the uncle's calling me. So that becomes almost unlimited. I don't want to scare anybody, but that's just the reality of the situation, right? But you know your own situation, right? I'd say average, like if I was trying to average amount, you're looking at like $1,200 average with the different guardrails that I stipulated. Yeah.
And also to remind everyone that in our resource booklets, we have a lot of the definitions, some of the the guidelines or prep tools that you can reference in planning this process, as well as free options like willful or need additional information like going to Steps to Justice website, etc.
Right.
To find out.
No, it's a very good plug. And I had a conversation with someone before mentioning that part about it. You know, we live in a world where, you know, ChatGPT exists, right? And all of these websites exist, right? People are, well, why should I go to you? Why shouldn't I go to them? And so we're having that conversation that, again, to my own detriment, I advise you that it's better to do that than have no will, right? So I'm not saying you got to come to me. I'm not saying you got to go to any of these other paid platforms. It's better to do that than have no will at all. What you're paying me for, what I think, is just my expertise, right? And the conversation I'm going to have with you, like I had today with you, which is conversational, which is going to have you thinking, which is going to have, you know, sort of give you advice as to, well, I see it this way and I don't see it that way, and other clients come to me and have you considered this, and my assessment, that's what you're paying for, right? And so I like that aspect of if finances is what's preventing you from doing it, yeah, don't pay a lawyer to do it. Like, do it, like, just get it done, right? But I'm not going to devalue myself, right? I know what I bring to the table in the sense of sort of guiding someone through the process, and so that's sort of what the rate is fixed to. Just circling back to what you were asking.
You can't put ChatGPT in front of the judge.
Yeah, and chat the robots still not yet. They're not accepting ChatGPT as an advocate when you go to court to fight the challenge to it. Not yet.
Sorry, and the witnesses if you were doing it by yourself?
Well, you'd have to find your own witnesses. And then you better remember what I told you, that it can't be the beneficiary, and it can't be your spouse, and all. That's the point, right? It's like, of course you can do it by yourself, right? It's like you can make a meal by yourself, but you pay to go to the restaurant to have a professional do it. Or your own plumbing, you could fix the pipes by yourself too. Yes.
So if you have a valid will, does it still need to go through the probate process, or it's just?
Yes. So probate, it sort of gets a negative connotation. Now we didn't have that aspect in this presentation because of time, but probate is just official, formal process of validating the will. Just think about it as that. It's a government set process. Think about it like, why should you accept any will as valid, right? It has to be a check and balance to it, right? And so we're not just going to take your word for it. Oh, I'm the lone beneficiary of my aunt's $1 million estate. It goes through a formal process. And so that's, but for people who have wills, right? That's the idea.
My next question is, if you have like an insurance policy or something like that, does it have to be stated in the will, or is that a separate thing?
It's a separate thing, but it helps. With my checklist, there's a provision certainly there for all insurance policies and their beneficiary, right? Because there's subtle interplay between the two, obviously, right? It's obviously something that is coming forth when someone dies, right? And so, but there are different things, like the life insurance policy doesn't really have anything to do with the will directly and vice versa, but I would mention it. You're going to name the beneficiary in the life insurance policy. If you name someone else in your will, that's going to cause a problem. I would argue, without giving too much legal advice, I'd argue that would be a losing battle. Which is another reason why lawyers' expertise is important, right? I need to hear everything from you and then advise you based on what you have going on. If you don't have a life insurance policy, that's different than someone who does, who has multiple different types of policies, right? Great question. Yes, sir.
So I was named an executor many years back.
Oh, lucky you.
And I didn't realize how much risk is involved in being an executor, right? Can you like kind of go over that a little bit of some of the risks of becoming an executor?
Yeah, and so again, it goes back to liability. As a solicitor, we deal with risk every day. We take that on, right? As sort of our burden across the bear, right? And we charge you accordingly, right? And then we have insurance and backing us up in case something goes wrong, because it inevitably does. And so to talk about the risk, not to scare anybody away from it, but you're stepping into the individual's role, right? So when someone sues the estate, they're kind of suing you. Now, personal liability is a little bit limited. You're shielded in some regards, right? Obviously. But you're stepping in the role of the individual. Again, going to court, depositions, right? The family accusing you of undue influence, and forcing my mom to write me out of the will, all of the, making you the executor. So liability from that standard, while you are, I would argue, insulated a lot in terms of personal responsibility, someone coming after you and suing you, you are the estate trustee, and you are going to be named. When you get that, when you're served with that summons, or that lawsuit in the mail, your heart's going to skip a beat because it's going to have, your name on it, right? And so in that regard, yes, it's certainly something to serious responsibility. Like I said, a lot of people just hire lawyers to do it, right? In terms of, and the good thing about the way I draft wills and most people draft wills is that we give a lot of leeway to the estate trustee. So the estate trustee could be the estate trustee, but then hire another firm to step in and be that person, and then pay that person out of the proceeds of the estate, depending on the size of the estate, right? But to your point, most people don't have that luxury. The estate might not be that sizable, so they can go and hire an accounting firm and a law firm and everything to do all of the work. Most of it falls on the individual. But risk reward. You might have a small estate, but then there's no liability in a small estate. No one's going to take you to court. No one's going to sue you. There's not going to be everybody fighting over debt, right? You wouldn't be on the hook for personal debt, like things of that nature, right? If the person ran up as $700,000 worth of debt, the state is bankrupt. The state doesn't have enough to fulfill their responsibilities, and everybody goes their separate way. But great question. It is it's a serious role to have to play, and you've gone through it, so you know better than most. Absolutely.
Just to take that one further, does the estate provide for any protection for you as the executor? The estate in terms of if someone, since you're managing funds and finances and whatnot, now you get sued indirectly. It's not the estate. Is it the estate getting sued?
Yeah, the estate gets sued, right, but you're named as the executor, and I will say what it doesn't protect you is against fraud, right? So if you're in there distributing the estate and do something untoward, misrepresent in some way, or, I can't even think of a way how people do it. What they do is that the main way is that they pay themselves more than what the work they're doing. So the estate is worth $1 million, and you paid yourself $900,000 as the estate trustee to execute the estate. They're coming after you. They're coming after you first, and you will be on the hook for that because that's a fraud. You're mismanaging the estate, right? And so that's the way. But absent that extreme example, you're fairly safe from a litigation standpoint because, like I said, it insulates you in some regard, right? Not totally, and not gross negligence or fraud and things of that nature. But like I said, personal attack. Oh, I don't like you because you're telling me I can't get the my mom's estate. I'm suing you. That's not going to have any sort of merit, right? That's going to fall on his face. Yes.
Being a lawyer in this role, and I'm not saying you specifically, but do I get the person that I built the relationship with, or do I get any random person in their firm or in their office?
It depends. So my firm, So my firm is not a 700 lawyer firm, right? So you're going to get me, or I'm saying 9 times out of 10, right? But if you go to some of these big box firms, of course they have the guy who's on the TV, and then when you call them, you're getting the first year lawyer, right? And again, I'm not nothing against first year lawyers. Once upon a time, I was a first year lawyer, right? And they might actually be more invested in your file than a 20-year lawyer, to be quite honest, right? And so it just depends on the firm and what their sort of hierarchy is. If it's me, then for sure it would be more of me. I'm not passing it off to anybody, but personally, I believe, obviously, in what you're saying, like the customer service aspect. We built the rapport, right? And so all the meetings are with me, whatever the timeline is, right? And even more, increasingly more, older lawyer that I work with, I'm taking on more of his files, and he will pass his on to me. And sometimes that's like, oh, you're not Peter. I mean, oh, hey, my name's Sheldon. And we build a rapport, right? And then they sort of see like, okay, this guy's just as good as the other guy, sort of thing, right? But sometimes it's not like that. Where's Peter? Or he's on vacation. Oh, I only want to talk to Peter, right? And then it's like, okay, well, then you can wait, and you can wait until back from vacation, and hopefully you don't pass away before he gets back, right? And so that's how we do it that time. But in many ways, it's like any other industry. It's relationship driven, and I think that I do a better job as a solicitor and as a barrister, the better my relationship is with the client. If the person's standoffish or if we don't click, they're not going to tell me certain things that I need to know. And then it's going to later on when I find out, oh, you didn't tell me your common law, or this, that, and the third, where it's going to rear its ugly head. And so I try to make it as lighthearted. That's why I inserted some humor into the conversation, because it is a morbid topic, right? But I try to build that rapport, and I do believe that it's important.
Just to add to that, again, tell me if I'm wrong. And I only know this because I just wrote the bar, but I think under LSO guidelines, once you sign a retainer with the firm, you're giving permission for anybody at that firm to have access to your files. I don't know if I'm wrong.
No, you're not wrong. And normally what it is in the retainer agreement. And so even if it's not a default position by the LSO, what the LSO is directing you to is that when I have a retainer agreement, the language would be in there, right? Oh, and not because I'm trying to shirk my responsibility, but I could be sick, I could be whatever, right? Or there might be a time of the essence thing. There's something and you'll find out in law when you get these clients, is that, every client, whatever they have going on is the most important thing on planet Earth, right? And they don't care that you run a business and have other clients, and they want their calls answered, and they want the undivided attention. And I try to do, obviously I try to give them that experience as much as possible. But to the point, in the retainer agreement, there would be language stating that we reserve the right to pass it on to any other lawyer for a practical reason and just for a business reason. Like the 30-year partner is not taking care of your file. He's on a golf course somewhere. It's like the younger lawyers like us who are going to be carrying it. And listen, sometimes that works in your benefit because you have the person's undivided attention. And any question that they would, like any lack of experience they would have, they'll just talk to another person and ask, right? If it's a complicated file. Most of these are not terribly complicated. The interaction with the customer is probably the hurdle that you have to circumvent. Yeah. Any other questions?
Are there any misconceptions that you find the clients come in with, maybe because they watched a lawyer show on TV and they have an idea about the process?
For sure. Yeah, tons of misconceptions. I mentioned one with regards to probate. Oh no, we have to avoid probate at all costs. And I'm like, listen, there's no path just without probate. And you try to, sort of show them that it's not a bad thing. It's the way to validate it. Well, then, okay, so why did I think it was such a bad idea, right? Many, like you mentioned one with regards to, I want to see the guy who's on the TV. You don't always get to see the guy who's on the TV, right? So that could be a misconception. Formal things like the witnesses, like, well, I brought my son, why can't he sign, right? And then you sort of explain the process. But listen, like I said, we're professionals. We understand that there was a time where I didn't know any of this stuff, right? I had to learn it and go through the process. And so you handle every client with kid gloves, and some of them are coming in there in an emotional state, obviously. Some of the other misconceptions, things like capacity, right? A couple clients have come in wanting to sign a power of attorney for someone who had dementia. Very clearly had it. Like it was, and I had to inform them that unfortunately that time has passed. And they're like, what do you mean? The bank is asking me for this and that. I'm like, I'm sorry, as my role as a solicitor, I can't do this for you, and it really wouldn't even be worth the paper that it's printed on because it would be deemed that the person didn't have capacity, right? And so it's like a misconception. The timing is kind of the misconception, like when the power of attorney is kicks in and when the will kicks in and when you should do it, and the time is now. Like I said before, the moment you start, oh man, Auntie so-and-so forgot that today was Sunday, it's too late, right? And so you want to do that before those type of things. But, I'd say those are the misconceptions, generally speaking.
Just so I understand the retainer, how do you know the difference between a service that you need that's a one-time payment and an ongoing relationship?
Yeah, great question. And so the way, like I mentioned with other communities that have lawyers on retainer, that might be a misconception. What that means is that, you have me at your beck and call, right? Like if you know you're doing X amount of transactions a year, you have a lawyer on retainer because you don't want to sit down and wait for my schedule. And if I have availability, so you send X amount of dollars ahead of time, and then when the time comes, you call, or it's already the arrangement, and then we just keep on taking away from the retainer until you have none left, and you refill the retainer. That's what traditionally is known as a retainer. But the retainer agreement we were talking about is just outlining officially what our relationship is. And so to your point, it could be for just for this one will. Or it could be, no, I want you carte blanche, all my estate matters, from my trust to all my children, all of that stuff, and that's a different type of retainer. And so retainer is one of those words that sort of like, people don't necessarily know what's happening, but think of it as just as an agreement. It's outlined, and the reason why that's important is because you can imagine, right? Well, you'll do a will from somebody and they think that you are best friends with each other, and they'll call you 16 times after, asking you questions, and then at some point you have to refer them back to the retainer agreement. Hey, remember this was just for that will. If you want to do something else, then we can sign a different retainer. And so it can be limited in its scope, or it can be open-ended in the sense that you have me at your beck and call if that's what the provision provides.
So the movie's lie, then I can't just give you $1 and say,
yeah, you can't just hand me $1. The idea between that is, listen, attorney-client privilege, to be honest, you don't even need $1, depending on the situation, right? If I hold myself out to be a lawyer, and you're confiding certain information to me, and I give you the appearance, like, oh yeah, man, come and tell me your problems. I can help you with that. The courts have found that could be an attorney-client relationship, absent any money, right? And so you see a situation where, and I know the reason why I know it's absent any money, because you'll see situations, especially in criminal law, where the individual will be in custody, and I'm your lawyer. And I go to your first appearance, and then you don't pay me again after that. If I run out of money, I say, hey, give me money. And you're like, nope, I don't have any money. And it's difficult for me to get off of that file, right? Because you've already gone to the first appearance and gone, this person is almost like beholden to you at this point. And so you got to be careful as a solicitor. That's why we have the retainer agreement outlining exactly what the relationship is, because you don't want to get in a situation where you're working for free for the rest of your life for the
And you're paid after each visit?
No, so when I broke down the fees for Gavin earlier, I know how long it takes, right? So I assess on our first meeting how long it is. If you're a person that I can tell that this thing is going to go on, this is going to be a serious file, it would be a completely different retainer than what I normally do. What I normally do is like flat rate. You get 2 or 3 meetings out of that, and it never, what I'm saying, it's. So the amount that I quoted him when I said generally speaking, that's what the general amount was. Because I know this is going to take 2 meetings, and then you're going to come in, that's the rate I quote. If upon our first meeting, or before we sign the retainer, I get the sense that, oh, okay, this is a lot more. You said this was straightforward, but you're the CEO of a tech company. That's not going to be what I quote again. And I'll let you know that right away. And then we'll sign an agreement, a retainer agreement, outlining exactly what that will look like. So that would be more open-ended, whereas 9 times out of 10, ma'am, is just the flat rate. You get the meetings, you get the experience, and then we go.
It's reassuring.
Whoops. Okay, so this is some of the references. These sites are very helpful, Step to Justice, and here's the willful that was mentioned before. If you want to take a picture of that, or it's probably in your packages. Oh yeah, and then here is my contact.
Oh yeah.
Thanks, guys. Yeah, through all that, you see, I'm out here not even worrying about myself. My email address, email me at any time. That is my office number and my extension. If I'm not there, you can call back the office number, and the secretary or whatever will take a message for you. But again, if I was persuasive in any way in imparting in any of you or any of your relatives that a will is important, give me a call. We'll set something up like I mentioned before. I hope that I've had a conversational tone with you, and this is pretty much how it's going to be, right? And that, I would appreciate that a lot. That would be great, because it would show that A, I'm helping you out, and these types of PLEs are important, right? Yeah, so I'll leave that up there. I think that's the last one, but I think that's it.